Get ready for the dictation on the count of 3, 2, 1, start. The assessees are dealers in foreign liquor among other goods. They have been assessed to sales tax as dealers on sales or purchases of other goods under Section 3(1) of the Madras General Sales Tax Act 1959. Section 3(1) is the charging section, providing generally that a dealer whose total turnover for a year is not less than the specified amount shall pay a tax for each year at the specified rate. Turnover is defined in Section 2(r) of the Act. The relevant part of the definition is as follows. Turnover means the aggregate amount for which goods are bought or sold or supplied or distributed by a dealer either directly or through another on his own account or on account of others, whether for cash or for deferred payment or other valuable consideration. Total turnover is defined in Section 2(q) of the Act as the aggregate turnover in all goods of a dealer at all places of business in the state, whether or not the whole or any portion of such turnover is liable to tax. The question is whether the sales tax collected by these assessees under Section 21(a) of the Madras Prohibition Act 1937 can be treated as part of their total turnover. Section 21(a), so far as it is relevant for the present purpose, is in these terms. Every person or institution which sells foreign liquor shall collect from the purchaser and pay over to the government at such intervals and in such manner as may be prescribed a sales tax calculated at the rate of 8 annas in the rupee or at such other rate as may be notified by the government from time to time on other price of the liquor so sold. Counsel for the appellants contended, relying on several decisions of this court to which we shall presently refer, that the amount collected by the assessees by way of sales tax from the purchasers were part of their total turnover and as such liable to be taxed under Section 3(1) of the Madras General Sales Tax Act 1959. In Masons George Oeg's Private Limited versus State of Madras, this court considered the question whether inclusion of the amounts collected by the appellants in that case as sales tax under the Madras General Sales Tax Act 1939 was valid. The expression turnover in the 1939 Act meant, as it does in the 1959 Act, aggregate amount for which goods are bought or sold, whether for cash or for deferred payment or other valuable consideration. This court observed, when a sale attracts purchase tax and the take tax is passed on to the consumer, what the buyer has to pay for the goods includes the tax as well, and the aggregate amount so paid would fall within the definition of turnover so far as the purchaser is concerned. He pays for the goods what the seller demands, viz. Price, even though it may include tax. That is the whole consideration for the sale, and there is no reason why the whole amount paid to the seller by the purchaser should not be treated as the consideration for the sale and included in the turnover.